Ted Stewart, U.S. District Judge for Utah and best-selling author of the new book, Supreme Power, 7 Pivotal Supreme Court Decisions That Had a Major Impact on America, now in bookstores. Thank you so much for being part of 3 Questions today.
Thank you for the invitation.
You bet. How important is the U.S. Supreme Court in the daily life of American citizens as opposed to, say, Congress or the Constitution?
Well, very good question. I think the answer is that as contemplated by the founders, it has become supremely important. It was never expected that the Supreme Court would play the role in the daily lives of the American citizen as it has evolved to. The power that the federal government now has over the everyday decisions of Americans and American business and et cetera has been primarily responsible or came about primarily because of Supreme Court decisions, and that's what the book is largely about.
Can you give me an example of what you're talking about?
Back in the early 1940s, there was a farmer in Ohio who raised 23 acres of wheat when he had been told by the federal government he could only grow 11. And in that case, Wickard versus Filburn, the United States Supreme Court said, yes, the Congress of the United States can pass laws telling farmers how much grain they can grow. And if a farmer violates it, then he can be penalized. In this case, he was. That decision greatly expanded the power of the Congress of the United States in the area of interstate commerce, which has been the justification for almost every federal law in the area of civil rights, environmental laws, and very importantly to the American citizen, criminal laws. Because of that decision, we now have an immense number of actions that American citizens engage in that are crimes that were traditionally only crimes in a state sense. So that is just one example.
If that is the case, that the federal government or the U.S. Supreme Court can tell a farmer in Iowa how much wheat he can grow, doesn't that supersede the state's authority? And doesn't the state actually have ultimate authority over the commerce in its boundaries?
You're stating the law, the constitutional understanding as it was until the 1943 decision. It was very much understood that the regulation of commerce, the safety of workers, etc., would be performed by the states. But Congress passed laws. The Supreme Court said the laws were constitutional because we are going to restate what the Constitution intended when it said that Congress had the power to regulate interstate commerce. An example that may be seen, would perhaps seem very silly to an average citizen, but based upon this decision in Wickard, Congress would have the power, for example, to regulate how many cookies a housewife or her husband or spouse cooks, because the theory is that if you are cooking something and eating it in your own home, that could interfere with interstate commerce because you're not eating cookies that are manufactured somewhere and shipped across state lines. And it may seem silly, but the power is there if Congress ever decided to exercise it because of a Supreme Court decision back in the 1940s.
The Constitution set up 3 branches of government, the executive, the legislative, and the judicial. Do they share equal power, really?
In theory, yes. In theory, the checks and balances intended by the founders when they wrote the Constitution would assure that all 3 of them were under control of the others. But that balance has been undone because of Supreme Court decisions over the 230 years since the Constitution was written. I think it's very clear, and I think the average American would probably acknowledge this, that the Supreme Court has an extreme amount of power that dictates to the executive and the legislative branches in ways never intended by the founders. And the question is, Bob, whether or not the people who are observing these things and caring about them, are they comfortable with it? In fact, I would expand that to say, does any American feel comfortable with the power that the Supreme Court has now assumed for itself?
Well, the implication in American society is that if the Supreme Court decides it, then that's the law, that's it, the argument is over, you have to comply. Is that not the case?
That is the case. It is understood that the Supreme Court has no power on its own to enforce its decisions, but as long as the American people are willing to abide by whatever the Supreme Court decides, and as long as the executive branch in particular, but on occasion the legislative branch, helps to enforce the decision, then that power is there, and the Supreme Court is free to do what it wishes.
For our viewers who may not know, where do the police powers fall in the three branches of government? Are they not under judicial?
Police powers actually refer to a power that was and is understood to exist in the states. It is the power of the state to regulate the health, the safety, the morals, etc. of the people. And that police power is frankly the basis of many of the decisions that the Supreme Court makes. For example, in the area of abortion rights, the states were exercising their police power in passing laws to limit the right of an abortion. The United States Supreme Court, in its Roe versus Wade decision, said that the states were exceeding their police power in regulating abortions in the way that they did. A more recent case would be the Oberfeld decision dealing with same-sex marriage, where the states were exercising their police power to dictate what marriage meant in its state, the state. And the Supreme Court said the states in prohibiting same-sex marriages in those states where it still was prohibited 2 years ago were exceeding their police power, and thus they could not do it into the future.
So what gives the U.S. Supreme Court ultimate authority over what happens in the sovereign states?
There was a case, Marbury versus Madison, very early in our nation's history, 1803 to be exact, where the Supreme Court said that when it came to the issue of interpreting the Constitution, that was the power of the judiciary. And ultimately that means the power rests with the United States Supreme Court because they're the ultimate within the judicial branch. Years later, they expanded that to include the power to review decisions of state Supreme Courts. So ultimately they have assumed unto themselves this power to make this ultimate decision for both state judicial systems as well as the federal judicial system, and that simply is the source of their power today.
The U.S. Supreme Court has assumed power unto itself in several different cases throughout history. Is that not in and of itself a dangerous precedent?
That is a decision that I would hope every reader would make for themselves. I try very hard not to make it very clear to the reader what I think was a good decision versus a bad decision within those cases that we discussed. But I am concerned enough, and frankly the thing that prompted me to write this book was a part of a dissent by Justice Scalia in the Oberfeld same-sex marriage decision 2 years ago. And I'm paraphrasing him, but he basically said this. He said, I don't much care about the marriage laws in the respective states, but I do care who rules over me. And this decision today, this again is Scalia, is suggesting that the 320 million Americans are ruled by the 5 members of the Supreme Court who are in the majority. And so that is the question for the American people. Are they comfortable with being ruled in so many very important ways by 5 lawyers on the Supreme Court?
5 lawyers who are there for life, who can only be removed by impeachment or death or retirement, voluntary retirement, and who answer to no one.
That is a fairly accurate summary.
That's frightening to a lot of people.
Well, I would hope that some of those people might become engaged in the future in helping to determine who in fact sits on the Supreme Court, because when all is said and done, that is the only outlet that anyone who fears the power the Supreme Court has, and that is to engage in the process of who is to be the president, who nominates, who in the Senate is going to vote to confirm or not to confirm future Supreme Court justices.
Over the years, the U.S. Supreme Court has assumed power to itself and has overpowered the executive and the legislative branches in many ways. Whether it was intentional or not, was it inevitable because of the way the country and the government was set up?
Excellent question. I think it would be more accurate to say it was inevitable in the minds of some because of the way the country has evolved, not the way it was set up. The way it was set up, the founders clearly intended that the judicial branch would only exercise judgment, making a very honest and disinterested decision about the constitutionality of legislation that might be passed by the other branches and signed by the president. The way the nation has evolved in the minds of some, as we have grown, as our population has expanded, as the commerce has changed, all these other things, some would say the courts have had to step in to make the decisions that they have. But I would suggest a great justice of the mid-20th century, Friedrich Frankfurter, who sat on the Supreme Court for about, I think, 30 years. He once made the observation that not every political mischief can be solved by the judicial branch. The Supreme Court, I believe, has taken to itself the view that every political mischief ought to be solved by the judicial branch. And I don't know that that is a comfortable thing for most Americans.
So if this is the case, if the U.S. Supreme Court is the ultimate authority in this country, and it is causing a slippery slope of the Supreme Court, of the judicial branch, overpowering the executive and legislative branches, what can be done to fix it?
As I said a few minutes ago, it will only come about through a political solution. The political solution is that the Supreme Court be made up of members who respect the Constitution, who have a sense of humility about what their role ought to be, and are willing to exercise restraint so as not to amend the Constitution through Supreme Court decision making. And that is what I think some would argue has happened in recent decades.
In your book, you talk about how the Supreme Court comes down to two basic judicial philosophies, one of constructionism and the other of the Constitution being a living, breathing document. Which of those two is more likely to preserve an equal balance of power in the federal government?
I believe that if judges at every level, but in particular at the Supreme Court level, were to abide by the language and the intent of the Constitution, that there would be far less likelihood that they would be exercising powers that ought to be exercised only by elected officials, whether they be in the legislative branch or the executive branch. Strict construction theory or method of constitutional interpretation is based upon the premise that we are in fact a nation where the rule of law exists. The rule of law dictates that we have an underlying basic law from whence we work for everything else. That rule of law has always been based upon there being a constitution that we abided by. What is a little bit disturbing and almost frightening to me is that we are beginning to see some who say that we ought to simply discard the Constitution because it stands in the way of progress. Excuse me. In recent years, a very prominent federal judge said that he would never spend he would not ever encourage lawyers or judges to spend more than a minute or two studying the Constitution because it stands in the way of progress. A very prominent Constitution law professor at a prominent university said that we ought to simply discard the Constitution because it stands in the way of political decision making in Washington today. That is very frightening to me because, again, if we are to be a nation where the rule of law is dominant, we have to have the rule of law beginning with the Constitution and then going from there to a limited view of the power of government vis-a-vis the rights of the people.
If, as some suggest, we need to disregard the Constitution when it comes to judicial rulings, where then is the standard? Where is the foundation for, and the measuring stick by which judicial decisions are made?
Well, first of all, it's not going to happen, I believe. It will not be discarded. It will not be discarded in such a way that the American people would recognize it. But in a sense, it is being discarded on a case-by-case basis when members of the Supreme Court, majority members of the Supreme Court, say to themselves, my judicial philosophy, my political philosophy, my philosophy of life is the basis for my decision-making, instead of looking at, again, the language and intent of the Constitution. But to be more accurate in answering your question specifically, we would have no basis. We would have no foundation. We would have no starting point. We would have whatever the elected officials of this nation could get away with, and whatever the judges would allow them to get away with.
Of the 7,000 to 8,000 cases that come before the U.S. Supreme Court for consideration each year, the justices take only 80 to 100. On what basis do they decide which cases they're going to hear, and to what degree do politics play a role in the decisions of which cases they hear?
To answer that question would put me in a position of trying to understand the thinking processes and mindset of 9 men and women that I do not have that kind of insight. There have been books, many books written, trying to answer your question, and frankly, no one has ever been able to come up with a precise answer. But there are some fairly obvious examples of cases that they have to take. Some years ago, we had a very controversial problem with the way we were conducting our sentencings in federal criminal cases. And basically, the Supreme Court said that the sentencing guidelines that we were relying on were unconstitutional in a case involving a similar system in the state. Well, suddenly we were sentencing people with the fear that we may have the Supreme Court ultimately within a matter of months or year or so say to us, every sentence that you announced for such and such criminal defendant was unconstitutional. So that case went to the Supreme Court within a matter of months. Another great example is whenever you have different circuits making decisions interpreting federal law or the Constitution differently, the Supreme Court says we've got to reconcile those. And any major political issue, for example, the election of 2000 was an example of where the Supreme Court took the case without anyone doubting that they would. But beyond that, Bob, what they use to decide is a mystery to many. Almost every year somebody is surprised when their case is not taken, and probably just as many are surprised when their case is taken by the Supreme Court.
Last week, the LDS Church filed a friend of the court brief with the U.S. Supreme Court case regarding a bakery in Colorado that was asked to bake a cake for a same-sex wedding. The bakers refused to do so. This issue has gone all the way to the Supreme Court. The church is arguing religious freedom on this. What other issues are in play in this case that the public may not be aware of that might lead to an understanding of what the court will ultimately decide?
May I beg off and not answer that one? That one, I think, would get me into an area where if I answered it, it may preclude me from considering or being able to hear some cases in the future.
Oh, really?
It would.
Okay.
I'm sorry, Bob.
No, that's fair enough.
Yeah.
That's fair enough. So what do you really think? Don't answer that. Don't answer that. Well, then let's talk about this. There are conflicting interests built into the Constitution. The ones I'm thinking of are privacy versus security, religious freedom versus discrimination and equal protection, freedom of association versus discrimination, and there may well be others. When those conflicting issues come up, how do the justices figure out which value or which interest weighs more than the other in any given case?
Well, Your question suggests that ultimately there are considerations other than a strict construction approach to making those decisions. The strict construction approach, again, would say, what does the Constitution say? What was the intent of the founders? What cases have we considered and decided in 200 years that we've been sitting as a Supreme Court that might suggest an outcome? The concern I have is this idea that they put themselves in a position of becoming philosophers or like legislators and weighing these different concerns, which is exactly what the founders did not want the courts to do. They did not want them to impose their will. That's the language used in the Federalist written by Hamilton. The judges are not supposed to impose their will. They're simply to exercise judgment. The evolution of the court system has suggested that they more and more do impose their will. And judgment is certainly exercised in many, many cases, but far more often today it's the will of the judges. And that is something that I think many people think is great. Many people who are listening tonight are going to think this is great, the way the Supreme Court has stepped in to make the decisions that they have. Many of the outcomes of these cases, most Americans are very comfortable with. But I would always come back to this question, are they comfortable with the idea that 5 members of the Supreme Court, unaccountable to the American public, get to make these decisions and do so not because of a strict interpretation of the Constitution, but rather putting into play their own value system? That's the concern I have. That's a concern that has been expressed and been the justification for many of the dissents of members of the Supreme Court over the last several decades who are concerned with what their majority members are doing.
Recently, the Supreme Court ruled in favor of part of the Trump administration's ban on travel from certain Muslim countries. Some people were surprised by that. Should they have been?
The courts have become involved in more and more issues involving matters well beyond that which I think was contemplated by the founders. This may or may not be an example of that. I think the Supreme Court will be making a decision relatively soon as to whether or not this was something appropriate for the courts or not. The Supreme Court begins its next term on October 2nd. The Supreme Court will be deciding cases not only involving President Trump's travel ban, but they'll be deciding cases on immigration enforcement, on political gerrymandering, religious liberty, whether or not the government should have access to our cell phones. Many important cases, many important decisions were made by the Supreme Court. I think it's incumbent upon the American people to watch the Supreme Court, to observe the decisions and the justification for those decisions, and to decide in their own minds whether or not they are, as Justice Scalia said, comfortable with the idea that they're ruled by those 5 members of the majority of the Supreme Court.
Does it really matter whether they're comfortable with it?
It matters only in that going forward, they can play a role in deciding who sits on the Supreme Court.
In 1990, there was a case, Missouri versus Jenkins, wherein a federal judge imposed a tax to fund the segregation of schools. Is that where we're headed? That's a legislative operation.
The Supreme Court said he was well within his rights in doing so. He ultimately required the expenditure of over $2 billion to upgrade the Kansas City School District in order to encourage students who live in the suburbs to come to the Kansas City School District to receive their education. In the end, the Kansas City School District was decertified because his experiment, as well intended as it was, and his desire for improving the plight of primarily African American students in the Kansas City School District was absolutely noble. It was required by the mandates of the Supreme Court to try to end the segregation of that school district. He came up with a method for doing so that failed. But in the course of that, he was given authority to raise taxes, to find the funds to build the schools, the new schools, etc. That ought to be of some concern to the people of America, because that rolls into one judge, the legislative, the executive, because he was basically running the school district, and the judicial all into one, thus obliterating the checks and balances that were intended to prevent that kind of exercise of power in one man and one branch.
Whatever happened to that ruling? Did it stand, or was it overturned?
Yes, it has never been reversed. The Supreme Court has never been back before the Supreme Court, but other courts have relied upon that decision, Missouri versus Jenkins, in order to require the raising of taxes in other instances as well.
What do you hope is the accomplishment of the book that you have written? Supreme Power, 7 pivotal Supreme Court decisions that had a major impact on America. What do you hope to accomplish with the book?
I hope to do 2 things. Number one, I hope to inform the reader, the American public, exactly how much the America that we live in today has been shaped by court decision, specifically the 7 Supreme Court decisions that I discussed. And secondly, it is to encourage them, if not perhaps even challenge them, to ask themselves a question: am I comfortable with being ruled by 5 lawyers on the Supreme Court? The question that Justice Scalia, in one of his last great dissents, stated was a source of great discomfort to him. Is it uncomfortable to most Americans, or is it something that we have grown accustomed to? And because so often the decisions are what we agree with, we're all right with it. We're all right with the method. We're all right with the means to the end. But what happens when the end is different from what we want? Are we going to remain comfortable with the way the Supreme Court has assumed the power that it has?
There are those who equate racial discrimination with sexual orientation discrimination. In the courts and in the judicial process, is that a viable comparison?
Bob, I'm sorry, but that would, for me to answer that, would involve an extraordinary amount of background into the 14th Amendment, what was intended by the Equal Protection Clause, and how it has evolved, and so on. I'm not sure you want.
What time do you have to be to work?
I'm happy to give you that answer.
Can you give me a Reader's Digest answer?
The Reader's Digest answer is this: the 14th Amendment to the Constitution, passed after the American Civil War, said that the citizens of the United States were entitled to equal protection under the law. That language, that amendment to the Constitution, was designed almost exclusively to deal with what were then known as the black laws in the South, where there was great discrimination. A African American who committed a crime could be sentenced to or could be convicted of a crime very different than white citizen would be, and would receive much more severe sentences. African Americans were not allowed to sit on juries, et cetera, et cetera. They were not given equal protection under the law. Because of that, the 14th Amendment was passed. Those black laws were intended to be erased. What happened thereafter, though, was the very clever lawyers began to see that language, equal protection, and see that opened a door for them to use it in other ways. And because of that, the Supreme Court had to come up with a method of dealing with all these discriminatory laws. I mean, we as individuals discriminate all the time. You married a wonderful woman, you excluded a whole bunch of other wonderful women. I did the same.
Hearts broken all over the place.
Yeah, in your case, I'm sure, especially.
No, I was thinking of you.
But we discriminate when we choose a group of friends or an organization to join and exclude others. So there's personal discrimination all the time. Government discriminates. If you're 15 years old and you want to go drive a car, you can't do it. If you want to practice law in the state of Utah without a license, you can't. You can't build a home and hold yourself out as a contractor without passing certain exams. We discriminate. So the Supreme Court was faced with this question: how do we decide what discrimination is legal and right and that which is not? And they came up with a very complicated test. And they said, in essence, if you are discriminating based on race, age, national origin, if the state cannot prove that there is a compelling state interest in regulating and discriminating in that way, and that they only came up with the most limited way of dealing with the problem that they saw, then that is unconstitutional. But for everything else, all you have to do is come up with what is known as a rational basis for your discrimination. You've got to be able to prove that a 15-year-old ought not to drive because they're not quite mature enough, not as mature as a 16-year-old. For example, that would be a rational basis. The question is whether or not sexual orientation has now moved into that category of cases that the Supreme Court will decide with strict scrutiny. The Oberfeld decision implied that yes, that they have, although they did not state that outright. But going forward, the Supreme Court will probably be faced with questions that will be all within that framework.
Can you foresee unintended consequences in regard to this?
I could, but if I answer that, then I will probably preclude myself from ever hearing those cases.
All right. The book is Supreme Power, 7 Pivotal Supreme Court Decisions That Had a Major Impact on America. The author is U.S. District Judge Ted Stewart. Thank you so much for being part of 3 Questions.
Thank you, Bob.